I have here 13 questions and answers on the never-ending topic of age of sexual consent. Hopefully, this will put the final nail on the coffin with respect to the toothless assertion that the age of sexual consent is 18. Question number 1. What does it mean when we say age of sexual consent? Answer: it is that age where a minor can validly give consent to sexual intercourse without her partner incurring criminal liability. Question number 2. What is the age of sexual consent in the Philippines? Answer: before it was 12 years old under Article 266-A, Subdivision 1, Paragraph D of the Revised Penal Code. Now, it has been increased to 16 years of age pursuant to Section 1 of RA 11648. Question number 3. Article 266-A, Subdivision 1, Paragraph D, as amended by Section 1 of RA 11648, expressly refers to the commission of statutory rape. So why do you say that it refers to age of sexual consent when there is even no mention of such term in the law? Answer: sexual consent means the consent given by a person signifying her voluntary agreement or submission to have carnal knowledge with another. Now, the validity of the sexual consent depends on the age of the minor giving the same. If the one giving sexual consent to sexual intercourse is under 16, her sexual partner will be criminally liable for statutory rape. This is so because a minor below 12, now 16, is deemed by law to be incapable of giving rational consent to sexual intercourse, as ruled in the case of Bangayan versus People. Thus, the above provision refers to age of sexual consent because statutory rape is the default crime that is committed when a person has carnal knowledge of a minor under 16 years of age. Question number 4. Why is a minor below 12, now 16, deemed by law to be incapable of giving rational consent to sexual intercourse? Answer: this is because the law presumes that such minor does not and cannot have a will of her own on account of her young age. Thus, her consent is immaterial because of her presumed incapacity to discern good from evil or from right from wrong, as ruled in the case of People versus Tulagan. Question number 5. There are those who say that the age of sexual consent is 18 because there is nothing in the revised penal code or in RA 11648 that specifically states that the age of sexual consent is 16. Do you agree with that assertion? Answer: no. To those who are asserting that the age of sexual consent is 18, let me throw the question back to you. Is there also a law that specifically states that the age of sexual consent is 18? There is none, right? A too literal reading of the law constricts rather than fulfills its purpose, and the purpose of RA 11648 is clear. That is, to make 16 years of age as the reference point in determining the validity of a minor's consent to sexual intercourse and other sexual acts. Question number 6. Are there Supreme Court decisions that recognize the age of sexual consent to be 16 years of age? Answer: the term sexual consent is actually a term born out of judicial interpretation. Prior to the enactment of RA 11648 raising the age of sexual consent from 12 to 16, there is already a judicial consensus that the age of sexual consent is 12, now 16. as can be gleaned from the rulings of the Supreme Court in Bangayan versus People and People versus Tulagan, to name a few. Question number 7. What about other sexual acts, meaning acts other than sexual intercourse, committed against a minor who is below 16? Does the term age of sexual consent still apply? Answer: yes. Since a minor under 16 is deemed by law to be incapable of giving rational consent to sexual intercourse, then with more reason should a minor under 16 be incapable of giving consent to sexual acts of a lesser degree, like sexual assault under Article 266-A, Subdivision 2 of the Revised Penal Code as amended by RA 8353 in relation to RA 11648, and acts of lasciviousness under Article 336 of the RPC as amended also by RA 8353 in relation to RA 7610 and RA 11648. For example, X, 15 years old, allowed her 25-year-old boyfriend Y to kiss her neck and caress her breasts. Here, even if X gave her sexual consent, Y will still be criminally liable for acts of lasciviousness because X, who is under 16, is deemed by law to be incapable of giving rational consent to such sexual act. Question number 8. Is there an instance where a minor under 16 can validly give consent to sexual intercourse and other sexual acts without her sexual partner incurring criminal liability? Answer: yes. There is an exception to the rule that a minor under 16 cannot validly give consent to sexual intercourse and other sexual acts. Under Article 266-A, Subdivision 1, Paragraph D of the Revised Penal Code as amended by Section 1 of RA 11648, a minor 13 years old and above but below 16 can validly give consent to sexual intercourse and other sexual acts provided that the age gap between the parties, meaning between the sexual partners, is not more than 3 years, and the sexual act in question is consensual, non-abusive, and non-exploitative. Question number 9. There are those who rapidly assert that the age of sexual consent is 18. What can you say to that? Answer: that is a toothless assertion, all bark but no bite. No amount of wordplay or circuitous discussion can cover up for their lack of a legal or jurisprudential basis. Question number 10. There are those who rely on the case of People versus Udang as their basis for saying that the age of sexual consent is 18. What can you say to that? Answer: the ruling in the Udang case to the effect that a child, meaning below 18, is presumed by law to be incapable of giving rational consent to any lascivious act or sexual intercourse has been overturned by the Supreme Court en banc in the case of People versus Tulagan. Now, to assume that 18 is the age of sexual consent would be to make every act of sexual intercourse or lascivious conduct with a minor automatically illegal. This is a wrong interpretation because it would render ineffective the criminal law provisions on statutory rape, statutory acts of lasciviousness, child prostitution, sexual abuse, and qualified and simple seduction. Question number 11. Why would such interpretation render ineffective the criminal law provisions on statutory rape, sexual abuse, etc.? Answer: had it been the intention of the law to punish individuals who engage in sexual intercourse or lascivious conduct with children or those under 18 years of age without qualification, then there would have been no elements that must be satisfied first before an individual could be convicted for such crimes. For example, Mere sexual intercourse with a 17-year-old minor does not make her sexual partner automatically liable for child prostitution or sexual abuse under Section 5B of RA 7610. It must be proven first that the 17-year-old minor engaged in sexual intercourse due to money, profit, or any other consideration, or due to the coercion or influence of any adult, syndicate, or group. Question number 12. Others would also argue that the age of sexual consent should be 18 kasi pag 18, walang conditions whereas pag 16, ang dami pang tseche-boreche. What can you say to that, Fiscal? Answer. That is an opinion with no legal leg to stand on. That is questioning the wisdom of the law which only Congress can decide upon. Go to Congress and demand from your legislators that the law should be amended increasing the age of sexual consent from 16 to 18. Otherwise, your opinion will just be a mere opinion based on an assumption devoid of legal basis. Besides, the issue under consideration is at what age can a person be allowed to give sexual consent? And the answer is 16. There is no question, and it was never an issue, that a person who is at least 18 can give sexual consent for the simple reason that she is no longer a child. Question number 13. Why should we go to Congress when we already believe that the age of sexual consent is 18? In other words, it is our belief that the age of consent is 18 because it is based on law. What can you say to that assertion, Fiscal? Answer. Where is the law or the jurisprudence you have been harping about? Take note that it is one thing to assert, it is another thing to prove. Unfortunately, nothing has been presented, which means that there is nothing further to discuss upon. No contest. Case closed.